Assalamualaikum, a very good day to Madam AZLIN and my fellow friend. Today we are from Group 1 and we are going to present the poster about Islamic banking legal framework in Malaysia. So before I go further, let me explain what is legal framework. So legal framework comprise a set of documents that include the constitution, legislation, regulation, and contract, or in other words, a broad system of rules that govern and regulate decision making, agreement, and law. In our topic, we are going to talk about the law and regulation that govern Islamic banking in Malaysia. So, Malaysia has a unique legislative framework consisting of mixed jurisdiction and mixed legal system, namely the common law and Sharia. The growth and development of Islamic banking industry are supported through good governance and its comprehensive legal framework. As Malaysia is one of the common law countries, it is very essential to have standard law of practice which harmonize both Sharia and civil law. The integration of these two traditions is really necessary in the context of Islamic banking in Malaysia. As Malaysia operates a dual financial system, the regulatory framework for Islamic banking is by design very similar to the conventional framework, as to avoid regulatory arbitrage between the two sectors. Banking regulation in Malaysia are heavily influenced by the world best practices and financial standard of the international standard setting body. At the time of writing, there is virtually an absence of regulatory framework that is catered to risk-sharing banking. Since the present setup where Islamic banks are operating is dominated by interest-based banking, the existing framework for Islamic banking in Malaysia is considered robust and comprehensive. Islamic banking refers to a banking system whose concept, operation, and activity are founded on the Islamic regulation. That is, all activities and transactions of the Islamic bank must be founded on the Sharia principle. The main distinction between Islamic and conventional bank is that Islamic bank do not engage in riba, which is expressly forbidden in Islam. Islamic bank exists to serve the requirement of Muslim in banking and to provide alternative to the rest. The management is based on Islamic precept of justice and fairness in the benefit of society. The ijma, agreement or consensus among Muslim jurists, and qiyas are also affected by Sharia. Muslim jurists apply a previous judgment to a new issue by drawing comparison. It explains the Quran and Hadith in layman terms. In particular, the incentive structure of the Islamic Banking Act 1983 IBA, Takaful Act 1984, Central Bank Act 2009 CBA, and the latest one is the Islamic Financial Services Act 2013 IFSA, and relevant guidelines are closely examined to identify any previous incentive incompatible with risk sharing. Moving on to the next important thing in Islamic banking, the Sharia Advisory Council (SAC) of Bank Negara Malaysia was founded in May 1997. The SAC is empowered to determine Islamic law for Islamic banking, takaful financial and development financial businesses, as well as any other business founded on Sharia principle and regulated by the Bank Negara Malaysia. The SAC role and power were enhanced in the recent Central Bank of Malaysia Act 2009, which made it the sole authoritative body on Sharia concern pertaining to Islamic banking, takaful and Islamic finance. The SAC judgment supersedes any contrary Sharia ruling issued in Malaysia, and the court or arbitrator must follow the SAC ruling in any proceeding involving Islamic financial transaction. By virtue of the CBA, the BNM Sharia Advisory Council (SAC) has the authority to judge Islamic law on any financial situation and to issue Sharia decision upon request. BNM must consult the SAC on any Islamic financial businesses matter requiring a SAC ruling on Islamic law. A court can submit any Sharia question in proceeding connected to Islamic financial firm to the SAC for a binding judgment, Section 56 and 57 CBA. Next is the important act for Islamic banking in Malaysia to follow, which is Malaysia has in 2013 introduced a new act, IFSA, with the intention to reconfigure the Islamic financial system from risk transfer to risk sharing base. IFSA 2013, an act to provide for the regulation and supervision of Islamic financial institution, payment system and other relevant entity, and the oversight of the Islamic money market and Islamic foreign exchange market, and to promote financial stability and compliance with Sharia for related, consequential or incidental matters Besides that, the Security Commission has been aggressive in adopting several steps to promote Islamic banking and capital market practices in the country, to promote the orderly development of the Islamic capital market, norm governing the issue, and offering a wide range of Islamic investment vehicle and services are continuously reviewed. The SAC of the SC also has a strong Sharia governance framework, evaluating and deliberating on Sharia matters relating to capital market products and services in Malaysia. The SAC would provide better clarity and uniformity on Sharia-related capital market concern. The SAC requirement must be followed by all Islamic banks participating to ensure the Islamic banking system remains strong and compliant with all regulation and law.
Assalamualaikum and hi, my name is NISA BINTI SAMLAH with metric number 269439. So in 2013, the Islamic Financial Services Act IFSA 2013 was introduced. The Act was enacted to provide for the regulation and supervision of Islamic financial institutions and oversight of the Islamic capital market to promote Sharia compliance and financial stability. It consists of 18 parts containing 291 sections and 16 schedules, and it emphasizes 4 key dimensions, namely a Sharia governance framework, Sharia standard for each Islamic financial product, preemptive measure to address issues that may affect the interests of depositor and policyholder, and lastly, the effective functioning of Islamic financial mediation.
For Suruhanjaya Security or Security Commission Malaysia, Islamic Bank must follow the rules and guidelines set by the SC, because most of them do business with other countries, invest in other countries or trade with other countries. So they need to follow the rules and guidelines set by the SC, as we acknowledge that the SC has direct responsibility for rulemaking, enforcing regulation pertaining to the capital market, and ensuring sustainable market growth and development, among other things.
Next is changes after applying IFSA 2013 as legal framework for Islamic banking in Malaysia. IFSA 2013 repealed existing banking regulation on Islamic banking and finance, and it also revised the accounting standard under which Islamic financial institutions prepare their account. One of the main changes are the product disclosure sheet (PDS) for financial consumer and potential investor to make informed decision. The product disclosure sheet for investment account product was insufficiently detailed. Prior to the implementation of IFSA 2013, the product disclosure sheet had little or no information on the risk involved, product suitability, investment strategy, historical performance, possible investment outcomes, indicative rate, and profit calculation. Before investing, financial consumers should be educated or warned about any potential risks. Furthermore, the distinction between deposit and investment account was unclear. In 2014, Bank Negara Malaysia published a policy statement on investment accounts that outlines the IFSA 2013's regulatory standard for investment account behavior. One of the most important requirements is that the investment accounts product structuring, including source of funding, investment purpose, profit distribution and agency fee, investment tenure, valuation process, and termination clauses be fully disclosed. Second, profit smoothing practices are necessary for both conventional and Islamic banking for assuring stable return for account holder, with principal guarantees are used to safeguard both deposit and investment account holders. Islamic banks are not permitted to utilize profit smoothing tactic under the IFSA 2013. Furthermore, there has been a lack of consistency in referring to the investment account, which is sometimes stated as equity and other times as liability. In addition to achieving liquidity criteria and risk objective, bank must clarify capital risk and valuation risk under IFSA 2013. This easily leads to the third issue, risk management in the financial sector.
Consequently, this brings us to the third issue, which is financial risk management. The Islamic Financial Service Act 2013 acknowledged the significance of Sharia non-compliance risk and explained the legal penalties for violating Sharia principle. In accordance with the Section 28(5), any person who contravenes subsection 1 or 3 who commits an offence and is liable upon conviction to imprisonment for a term not exceeding 8 years or to a fine not exceeding 25 million ringgit or to both. And Section 1 already discussed the significance of Sharia compliance, while Section 3 recommends remedial strategy to manage the risk of Sharia non-compliance in the workplace. Any activity that does not comply with Sharia must be stopped immediately and be reported to the bank and the Sharia committee within 30 days according to the Section 28(3) of the Islamic Banking and Finance Act. Next, financial reporting is another modification that Islamic financial organizations are required to implement under the Islamic Financial Service Act of 2013. One of the primary goals is to increase transparency while also improving Sharia compliance. It has been pointed out by AZLIN et al. 2016 that the balance sheet structure of Islamic banks is characterized by significant asset liability mismatch. Moreover, according to AZLIN et al. 2016, such misalignment exposed the bank to a vicious circle of liquidity gaps is necessary the requirement for a loan facility from the central banks. Financial reporting is critical to the company governance and Sharia compliance, and it should be treated as such. And according to the Bank Negara Malaysia 2014 policy document on investment account, Islamic financial institutions are required to disclose the following information in the annual financial statement, such as accounting policy, movement of fund, average profit sharing ratio, declared rate of return to investment account holder, agency fee and performance incentive fee. The Islamic financial institution are required to distinguish investment account from other types of deposit and to record investment account as separate item from their own equity and liability in accordance with applicable legislation AHMAD et al. 2019. Lastly, the changes to Islamic banking regulation in Malaysia is about a rate of return framework. There is a great emphasis placed on the treatment and distribution of profit and the rate of return to investment account holders. In addition to the requirement for the performance report, distribution table, and warning disclaimer disclosure. It was stated in 2014 in a policy document on investment account issued by Bank Negara Malaysia that under Islamic Financial Institution Security and Exchange Commission Act, the priority of payment for investment account upon liquidation of the Islamic financial institution is treated separately from Islamic deposit. This is by Bank Negara Malaysia 2014 PUAN. Prior to the implementation of IFSA 2013, all deposit will receive from deposit and investment account were placed into a share pool of fund for investment purposes, and the predicted return was calculated as a simple time series average of the monthly rates of return for a specified period of time. Due to the change the Islamic Financial Service Act 2013, the return on an investment account is based on the actual performance for underlying asset and therefore susceptible to financial losses and market instability.
The Essential Law of Islamic Financial Service Act 2013. The first essential law is payment system. Under the payment system, provision is strengthened to regulate designation of payment system and Islamic payment instrument. Designation of payment system in subsection 39(1), where the bank is of the opinion that a disruption in the operation of the payment system could affect public confidence in the overall payment system of Malaysia or impact the monetary or financial stability in Malaysia. A. In the case of an operator of a payment system who is subject to the supervision or oversight of another supervisory authority in Malaysia. the minister on the recommendation of the bank and such supervisory authority. Designation of Islamic payment instrument in subsection 41(1), where the bank is of the opinion that A, an Islamic payment instrument may be of widespread use as a means of making payment and may affect the payment system in Malaysia, and B, it is necessary to maintain the integrity, efficiency, and reliability of the Islamic payment instrument. Next, under Sharia requirement, subsection 28(1), an institution shall at all times ensure that its aims and operation, business, affairs, and activities are in compliance with Sharia. Under subsection 28(2), for the purpose of this Act, a compliance with any ruling of the Sharia Advisory Council in respect of any particular aim and operation, business, affair, or activity shall be deemed to be a compliance with where an institution becomes aware that it is carrying on any of its business, affair, or activity in a manner which is not in compliance with Sharia, or the advice of its Sharia community, or the advice or ruling of the Sharia Advisory Council, the institution shall A. immediately notify the bank and its Sharia community of the fact, B. immediately cease of carrying on such business, affair, or activity, and from taking on any similar business, affair, or activity, and within 30 days of becoming aware of such non-compliance or such further period as may be specified by the bank, submit to the bank a plan on the rectification of the non-compliance. The third essential law of IFSA 2013 is regulatory objective and powers and function of banks. In regulatory objective, subsection 6, the principal regulatory objective of this Act are to promote financial stability and compliance with Sharia, and in pursuing this objective, the bank shall A. foster the safety of soundness of the Islamic financial institution, the integrity and orderly functioning of the Islamic money market and Islamic foreign exchange market, safe, efficient, and reliable payment system and Islamic payment instrument, and fair, responsible, and professional business conduct of Islamic financial institution, and B. strive to protect the rights and interests of consumers of Islamic financial services and products. Powers and function of bank in subsection 7(1), the bank shall exercise the powers and perform the function under this Act in a way which is considered most appropriate for the purpose of meeting the regulatory objective of this Act, and the governor shall exercise such powers and perform such function of the bank on its behalf. Subsection 7(2), the powers and function of the bank under this Act are in addition to and not in derogation of the powers and function of the bank under the Central Bank of Malaysia Act 2009. 3. The bank shall from time to time keep the minister informed on matters relating to the exercise of its powers and performance of its function under this Act.
Hi, Assalamualaikum. Now, I will present about enforcement and penalties under the Essential Law of IFSA 2013. Bank exercise all the power of investigation provided under this Act if the bank believes that any person has committed an offence. We can see in 229 where the bank is satisfied or has any reason to believe that any person has committed an offence under this Act. The bank may cause an investigation to be made, and for such purpose may exercise all the power of investigation provided under this Act. And then in 230 about appointment of investigating officer, the bank may appoint an officer of the bank or any other person appointed under subsection 7(6) to be investigating officer to conduct an investigation under this division. Now we take a look about Islamic money market and Islamic foreign exchange market. The power of bank to specify standards of issue codes in Islamic money market and foreign exchange market. In 152, One, the bank may specify standards or issue codes for the purpose of developing or maintaining orderly conditions or the integrity of and ensuring compliance with Sharia in the Islamic money market or the Islamic foreign exchange market. And then, two, without limiting the generality for subsection 1, standards specify of codes issued under that subsection may include standards or codes relating to compliance with Sharia by the market participant or any person employed by such market participants in relation to their conduct or activities in the Islamic money market or the Islamic foreign exchange market. Lastly, in the essential law of IFSA 2013 is a prudential requirement. It introduced that institution refers to an authorized person or a designated payment system operator. In 57.1 about power of bank to specify standards on prudential matters, the bank may specify standards on prudential matters to promote A. The sound financial position of an institution, or B. Integrity, professionalism and expertise in the conduct of the business affairs and activities of an institution.
For conclusion, Islamic legal framework in Malaysia is justifiable and comprehensive since Malaysia operates a dual financial system where each component is appropriately equipped with full-fledged supporting mechanism. This banking regulation guide provide a high level overview of the governance and supervision of bank, including legislation, regulatory bodies, and the role of international standard, licensing, the role of liquidity, foreign investment, liquidation regime, and recent trend in the regulation of bank. BNM has broad power of supervision and control over banking institution licensed under the Islamic Financial Services Act 2013. In discharging its supervisory function, BNM adopt a risk-based supervision approach under which financial institutions are assessed and monitored based on the risk profile and efficacy of risk management system. PNM has issued various guidelines relating to prudential matters applicable to banking institutions, including standards relating to capital adequacy, Sharia, compliance, and the others law. As presented by us, Islamic Financial Services Act 2013 is a very important law for all Islamic banking institutions in Malaysia. The Islamic legal framework in Malaysia is very comprehensive, and this is very important to ensure that the Islamic banking system continue to gain attention, trust, and be able to compete with the conventional banking system. So that's all from us. Assalamualaikum.